students, today I will lecture on Chapter 11, Introduction to Contracts. A contract is a legally enforceable agreement. Elements of a contract include offer, acceptance, consideration, legality, capacity, and consent. Some types of contracts must be in writing to be enforceable. Offer is when a person or company proposes the deal. 2, acceptance is responding to the offer a certain way. 3, consideration is bargaining that leads to an exchange between the parties or bargained for exchange. 4, legality, the contract must be for a lawful purpose with the law. 5, capacity, the parties must be adults of sound mind. 6, consent, both parties must agree to the terms. And writing, some contracts, types of contracts, are required to be in writing to be enforceable. The definition of a contract is a promise that the law will enforce. Types of contracts. There are bilateral and unilateral, express and implied, executory and executed, valid, unenforceable, voidable, and void. And we will discuss all of those moving forward. Bilateral contract is where both parties make a promise to each other to do something. Goes both ways. Unilateral contracts are where one party makes a promise to the other that the other can accept only by doing something specific. It's a promise in exchange for an act. And we'll talk about examples. Express and implied contracts. Express is where the two parties to the contract explicitly state all of the important terms of their agreement. They express them by words or in writing, verbally, written. Or an implied contract is where the words and conduct of the parties indicate that the parties intend to make an agreement. It's implied from their conduct. Executory and executed contracts. An executory contract is when one or more parties has not fulfilled his obligations under the contract. It has not been completed. An executed contract, executed, is where all the parties to the contract have fulfilled their obligations under the contract. Everything is done and completed. Valid, unenforceable, voidable, and void agreements are the following. A valid contract satisfies all the law's requirements. Unenforceable contract is when the parties intend to form a valid bargain, but some rule of law prevents enforcement. Voidable, when the law permits one party to terminate the agreement, like if two parties enter into a contract, but one is a minor, then the contracting minor may cause the contract to be voidable. And void is one that neither party can enforce, usually because the purpose is illegal or one of the parties had no legal authority. Like a contract to buy and sell illegal drugs would be void because it's illegal. Even when there's no contract, a plaintiff may use promissory estoppel to enforce the defendant's promise if he can show that the defendant made a promise knowing the plaintiff would likely rely on it. The plaintiff did rely on the promise, and the only way to avoid injustice is to enforce the promise. Promissory estoppel is an equitable theory in which judges may impose that legal theory to enforce a promise even when it's not legally enforceable under contract law. Sources of contract law include the common law, which we know are case-made decisions based on precedents. Uniform Commercial Code, UCC Article 2 governs the sale of goods. What are goods? They're anything movable except for money, securities, and certain legal rights. And the Restatement of Contract are legal theories or treatise published in bound books. I've included an example of a North Carolina real estate contract on Blackboard, so you can see an example of what a contract looks like, and many of these terms would be included in the contract. So we will cover each of those legal theories that are covered in Chapter 11 moving forward. We will talk about offer. We will have a whole chapter on offer, a whole chapter on acceptance, a whole chapter on consideration, a whole chapter on which contracts are valid, void, unenforceable, moving forward. So thank you very much for listening and have a great day.